Our next speaker is William Thompson. And William Thompson is professor of criminology, law, and society, professor of psychology and social behavior, and professor of law at the University of California at Irvine. His research is on human factors associated with forensic science evidence, including contextual and cognitive bias in forensic analysis, and the communication of scientific findings to lawyers and jurors. He has many publications, but I'd like to mention the first one and the last one. So the first one is actually, if I'm not wrong, dates back to 1987, and it is the one that introduced the term prosecutor's fallacy, which we all use today with such a derogatory vein. And last, one of the most recent one is dates 2013, do jurors give appropriate weight to forensic identification evidence? Journal of Empirical Legal Studies. And there is his talk for today. Please join me in welcoming William Thompson.
I'm just tremendously excited to be here. I need to explain. Some 30-some years ago, I was a graduate student here in psychology, and I decided I needed to learn a little bit about the law, and I entered a master's program in law taught at this law school. And in that program, I took two courses that were particularly influential for me. One was a course in evidence taught by John Kaplan, who made use of some mathematical characterizations of evidence and argued with me endlessly about whether psychology is useful for talking about evidence. The other course that I thought was particularly wonderful was a course in constitutional law taught by a dynamic young professor named Paul Brest, who not only was he a great instructor, but he was a tremendously warm person. I recall that he invited all the students to his house and not only fed us, but he showed us the movie A Man for All Seasons and engaged us in discussion of the meaning and importance of law in society. And that was such a great experience. I thought, this is what a professor should be, you know. And so, Paul, you have long been one of my models for my own academic work, and so it's a particular honor to be here in an auditorium named for Paul Brest, and to have Paul Brest himself as a commentator on my paper. I hardly feel worthy of this. In any event, so the talk I'm giving might be one that is more relevant to what I learned from John Kaplan. I'm talking about how forensic scientists should talk to jurors, or how we should require them to talk to jurors about their findings. And I'm talking particularly about findings where forensic scientists compare two items to determine whether they had or probably had some common source. So did this latent print come from this finger? Did this bite mark come from these teeth? Did this blood sample come from this individual based on genetic characteristics and so on? So forensic scientists have traditionally presented their findings using categorical, what I call a categorical approach. They might, if it's really strong, say it's an individualization or identification, sometimes adding to a reasonable scientific certainty just to emphasize it. Sometimes they use terms like match, inclusion, consistent with, a little vaguer. It could be inconclusive, it could be an exclusion. Traditionally, latent print examiners would call it either an exclusion, inconclusive, or individualization. Other forensic scientists would equivocate or have intermediate categories, and the number of intermediate categories has grown. This is a set of intermediate categories put out by SWGDoc, the document examination people, at a 9-point scale. You can either have you can go from identification, a strong probability, highly probable, very probable, merely probable, indications, no conclusion, and so on. But notice it's all very categorical, and this approach to talking about evidence has come under serious criticism. One line of criticism that I have always found compelling is that to characterize findings in this way, and particularly to talk about the probability that items have a common source, requires a leap of logic. the analyst is actually looking at the two items and is concluding that they share certain rare or unusual characteristics, right? They both have the same DNA profile, and that's a rare profile. But the analyst then jumps to the conclusion that they probably have a common source. Now, logically, the analyst can't go from conclusions about the rarity of matching characteristics to conclusions about the probability of a shared source without making an assumption or taking a position on the prior probability that the items have the same source. Of course, to do that involves the expert taking into account aspects of the evidence beyond the scientific evidence that the expert's supposed to be examining. And so, in order for the expert to reach the kind of conclusions that we see the document examiners do and that forensic scientists have been presenting routinely for the last 100 years or so, necessarily requires that they be invading the province of the jury in some sense. All right. Or that they be drawing conclusions in a way that's illogical because they're not taking into account information that they necessarily have to take into account in order to reach those conclusions. So that's one kind of critique of this approach. The other critique is associated with the general call for quantification, the idea that the categorical system is less adequate than a system that's based upon some numbers. We see this strongly in a 2009 report on forensic sciences from the National Research Council. They declare quite strongly that all forensic science methods should have estimations of uncertainty and measurements. Forensic scientists shouldn't talk about things being uniquely associated with. It should be probabilistic. And their reports and any testimony must include clear characterizations of the limits of the analysis, including associated probabilities. So the pressure is to quantify, to say it with numbers rather than categories. And there are a number of arguments in favor of quantification, some of which have been mentioned. I mean, some people view a quantitative approach as being part and parcel of efforts to validate forensic science better than it's been validated, right? In order to talk about the value of forensic evidence, we'd like to see forensic scientists do some research so that they know how rare the characteristics are, how often they make mistakes, and so on. A second element that Sandy alluded to is that the numbers are thought to afford greater transparency. I mean, for an expert just to say, I'm an expert, I examined this shoe print, it's probably from this shoe. I have expertise, trust me, is somehow not as interrogable or testable as an expert just says, I examined the shoe print, I noted these following common features, and here I will give you an estimate of how rare these features are in some population. That can be examined more easily than simply the conclusion. And also there's an element of precision. And what does it mean to say that they match? This blood at the crime scene, I compared the blood at the crime scene and to the blood from the defendant, and it matches. Eureka, so there. How does it match? Well, they both contain hemoglobin, right? so I mean QED. It seems odd to talk about consistent with or a match or could have come from and so on without providing some numerical estimate of how likely that would be if they weren't from the same source. So those are perceived benefits of numbers, but it raises the question, what kind of numbers, right? How do we talk to jurors about numbers? Here are some candidates. I mean, one approach is to provide frequencies, sometimes characterized as match probabilities, as is done often with DNA evidence. So the expert might say, I've looked at this and there are shared genetic characteristics. The shared genetic characteristics would be found in one person in 10 million. So that would be like a natural frequency. Sometimes it's stated more as a probability, the probability of finding these characteristics in a random individual from whatever reference population is 1 in 10 million. So you could do it, you could characterize it in this way. In Europe, Australia, New Zealand, there's been strong advocacy by some forensic scientists for use of likelihood ratios. So the expert talks about the conditional probability of finding the evidence observed under alternative propositions, such as the defendant was the source of this blood or the defendant wasn't the source of the blood. or the shoeprint or whatever. And then the expert ends up saying things like, the evidence is X times more likely under the proposition that the defendant is the source than under the proposition that someone else is the source. Now, this has the advantage of being rather nice in that the expert is talking just about what experts know about, which is the probability of observing data under hypotheses. The expert doesn't have to get into the probability that the hypotheses are true or not, so the expert is confined to the expert's domain of expertise. But it's kind of hard to understand, right? So we know jurors have difficulty with this, and so in those jurisdictions, particularly in Europe, where the likelihood ratios are widely used, often experts also like, or instead to present what are called verbal equivalents. A group called the Association of Forensic Science Providers put out this chart showing the what they thought would be an appropriate verbal label to apply to various likelihood ratios. Now, how do they know that a likelihood ratio of 10 to 100 is moderate strength? I mean, this is based on no empirical research whatsoever. I mean, it seemed right. It seemed right, and so that's what they've been using. If you read, R versus T in some of these cases, it's been widely used. All right. So, will jurors understand these things? Which approaches are best? And the broader question: how should we go about evaluating jurors' reactions? I'm a psychologist, so I think that we should see how people respond to these things and see which presentation methods leads to the best response. But how do we evaluate what's the most desirable or the best response? This becomes a little tricky, but I have some ideas. I'm going to propose 3 criterion for a good response to evidence that I think we can use in deciding which format for presentation is better or not. One criterion is sensitivity to the strength of evidence. We want to present evidence in a way such that people will give more weight to the strong evidence and less weight to the weak evidence. So we want people's reaction to the evidence in terms of the amount of weight they give to it to be roughly commensurate to the strength of the evidence measured in some objective way. Now, there's worries that it isn't always so. This is a chart. This chart shows data from a study conducted by Christy Martiri and her colleagues at University of New South Wales. This has been causing consternation among forensic scientists around the world. What this shows is jurors' reactions in terms of mock jurors' reactions in terms of mean belief change when estimating odds to forensic science evidence. Excuse me. Let me go back here. This is shoeprint evidence, where characterized by either a numerical likelihood ratio or a verbal equivalent, where the strength of the evidence is either low, which means a likelihood ratio of 4.5, or moderate, likelihood ratio of 450, or high, likelihood ratio of 450,000, right? So as a logical matter, jurors should give very different weights to these 3 pieces of evidence. Looking across the chart, they don't, right? So really weak evidence, really strong evidence, it's all the same to them, at least with the likelihood ratio. When it's presented verbally, if the low evidence where the expert says it provides weak support is actually treated as exculpatory. Right? It's kind of, I suppose I think of it as being like writing a letter of recommendation for somebody saying, I weakly support this person. This person has my weakest support. I mean, it does, logically it should help, but it does more harm than good, right? So, but anyway, this kind of thing raises serious concerns about whether we're communicating effectively with jurors, right? So if they're insensitive to variables that should make a difference, that suggests there's a problem with the presentation format, does it not? All right. Now, another issue that I think is relevant when assessing these different formats is susceptibility to fallacious interpretations. We know that people get confused, the prosecutor's fallacy, the defense attorney's fallacy. And so, and this is particularly important to me, I tend to think that presentations that lead people to be more likely to reach fallacious conclusions on the evidence are worse than those that are less likely. So, when the DNA expert says the random match probability is 1 in 10 million, we don't want, and the prosecutor says, that means there's 1 chance in 10 million the defendant's innocent. We don't want people to reach this conclusion. All right, this is the prosecutor's fallacy. Here's the defense attorney who's arguing, well, he's not the only person that matches. There are 300 people who would match in the US, so there's like 30 other people who would have the matching profile. So really it means that the probability of guilt is 1 in 30. All right, that's the defense attorney's fallacy. That's also wrong. I mean, in both cases, the people are drawing conclusions from the scientific evidence without taking into account priors and the other evidence. It's a problem. And so presentations that are conducive to this, I think, are worse than those that are not. All right. Third criteria for evaluating goodness of presentation methods, and I know this will be the most controversial, so I'll throw it out there to see what you think, is the logical coherence of judgments, or what we might call Bayesian coherence. You can ask people to judge evidence in different ways. And Bayes' rule says the posterior odds should equal the prior odds toward times the likelihood ratio. And you can ask people, what do you think are the prior odds and what do you think are the posterior odds, and look at how much they shift. That would be one measure of weight of evidence. You could ask them to estimate the likelihood ratio. How more likely is this evidence under one proposition than another? And my argument is that it would be nice if these things cohere. That is, if you ask people to weight the strength of the evidence various ways and their judgments are consistent with one another according to Bayesian rules, that suggests to me they understand it better than if they give wildly inconsistent answers. We know people often do give answers inconsistent with Bayes' theorem. So if the prior odds are 0.1, like 10 to 1 against, and the likelihood ratio is 10, I mean, there are studies where people will say, well, if you ask them if you ask them what the posterior odds were, they will give you, 100 to 1. This is wrong, and it's what psychologists would call overvaluation of the evidence relative to Bayesian norms. The psychologists, I think, don't quite have, it could be that they're overvaluing it when they're shifting from prior to posterior, but it could also be that their estimates of the prior or likelihood ratio are off. I mean, we know that this is an inconsistency or an incoherence, which we can see. I mean, we often see undervaluation as well. So people often do this, right? And so my overall claim is that we would like methods of presentation to bring people closer to coherence, and that those that lead to greater coherence are better than those that lead to less coherence. But we can argue about that. Let's talk about some research that measures how people perform on these 3 dimensions when evaluating forensic evidence. And this is a follow-up to Martiri's data. The method, it was a jury simulation study. We recruited people from Amazon's Mechanical Turk. We actually did some measures comparing mechanical M-Turkers, as they call, to people we recruited from a local jury pool, and found similar patterns of reaction when we screened the Turkers. So we drew people from this online marketplace. We had them make judgments of the guiltiness of a criminal defendant in a case that was described with written summaries of evidence before and after receiving the forensic evidence. So the before judgment was the prior, the after judgment was the posterior. We experimentally varied the strength of the forensic evidence. We also varied the presentation format. We presented it as either a random match probability of 1 in 100 or 1 in a million. So 1 in 100 is weak, 1 in a million strong. Okay? Or a likelihood ratio of 100 or a million, or the verbal equivalence recommended by the forensic service providers of moderate and very strong. So we presented, so it's a factorial design. They got either strong or weak evidence that was presented either with an RMP, likelihood ratio, or verbal equivalent. We also varied the type of forensic evidence, either DNA or shoeprint match, characterized in these ways. Right? And so what we wanted to see is, are people sensitive to the differences in strength and how that varies as a function of the presentation format for 2 different types of forensic evidence. Here's the basic result on sensitivity. This is actually the percentage voting guilty, which I thought was a reasonable way of looking at how they reacted. And if we look at this, if we're concerned just about sensitivity, it looks like the random match probability approach does better. Look, the very strong evidence is given, leads to a higher conviction rate, and the moderately strong evidence, so the 1 in a million evidence leads to a higher conviction rate, and the 1 in 100 evidence a lower conviction rate for both DNA evidence, which is the top 3 panels, and shoeprint evidence, the bottom 3 panels. So for sensitivity, random match probability works. Likelihood ratio, well, it kind of works for DNA evidence, but for, for the shoeprint evidence, it goes the other way. So overall, people are not sensitive to the likelihood ratio. Same thing for the verbal equivalent. So this is looking like, all right, so they're understanding match probabilities. They're not understanding likelihood ratios. Does this mean we should use match probabilities? Well, it gets a little more complicated. Looking at fallacious interpretations, we looked at at whether they would agree with statements that were consistent with the prosecutor's fallacy and defense attorney's fallacy, where we said, did the expert tell you that the probability, that the probability of the defendant not being the source was 1 in a million? A very high percentage said, yeah, that was what the expert said. No, it wasn't what the expert said. But so we're getting, half to 2/3 of people would agree with fallacious statements, and this was true for both likelihood ratios and match probabilities. So not a lot of difference there. We also replicated Martiri's weak evidence effect, at least for a minority of participants, when the evidence was described as weakly supportive of the hypothesis. We still had some people thinking that was exculpatory. Now let's go to the comparison to Bayesian norms. This is a little trickier. We used this scale shown here to elicit their prior and posterior judgments of probability. So rather than having them state odds, which is a little awkward, they just had to check off something on this scale, how, from certain to be guilty to impossible that he's guilty, varying in increments of basically a factor of 10. So you could think of it as being close to a kind of a log scale. And what we wanted to see is how many steps up on this scale did they move after getting the forensic evidence. And in order to know whether they were doing it consistent with Bayesian norms, we also wanted to get some sense of what likelihood ratio would they assign to this evidence, or how strong did they assess the evidence to be, based upon their estimates of the conditional probability of certain kinds of errors. So we had participants estimate the conditional probability of 3 possible errors that we thought would affect the value of the forensic evidence. One is the probability of there being coincidentally a match. Right? So how could the matching forensic evidence be wrong? Well, the defendant could just match by coincidence, or the matching characteristic being reported by mistake due to the lab. There could be a laboratory error. Or the third way we thought was that the match could occur due to some sort of nefarious planting of evidence. Right? So those are the 3 ways we thought that this test could be wrong, and we asked our participants to estimate the probability of each of those events, which we thought were the 3 events which logically should affect the value of the evidence. Okay, we then combined these 3 probability estimates using this Bayes net shown here. So this is a Bayes net that, in the interest of time, I won't go into it at any great length, but we basically came up with a model, maybe an imperfect model, as Charles said, but this is our model of how one would combine the 3 sources of error and come up with a likelihood ratio, and use that model to compute a likelihood ratio for each participant. Okay? Then we use that likelihood ratio to update that participant's prior estimate, and we compared that with the participant's posterior estimate. So what we're asking is, did the participants when estimating the probability of guilt, did they update their judgments as much as Bayesian norms, based on this model, say they should have, based on a combination of these variables under the model? So I hope this is clear enough. We're basically asking, are jurors being good Bayesians in the way in which they shift their judgments in light of forensic evidence? Here's the answer. It turns out for DNA evidence, they look great. The dark bars are the change scores. How much does their judgment of probability of guilt change after getting the forensic evidence on that scale? And they go up 2 to 3 times. So they go up by a factor of 100 to 1,000 upward. And that's pretty much what the Bayesian model says they should do based upon their estimates of the probability of error. So there's no statistically significant difference between the change scores and the log likelihood ratios computed from the Bayesian model. When it comes to DNA evidence, people are really good Bayesians. They're a high degree of coherency, we would say. But now look at what happens with the shoeprint, and this I think where it becomes really interesting. The striped bars, which show the Bayesian norms, are lower for the shoeprint evidence, which shows that people didn't give as much weight to the shoeprint evidence when estimating error possibilities. I mean, they thought the probability of coincidence was higher, the probability of a frame-up was higher, the probability of error was higher, and so on. And that's all taken into account in the striped bars. So their estimates of error for shoeprint evidence were higher. But even so, the shift in their judgment of guilt was even lower than that. So what I think we're seeing here is that the shoeprint evidence is viewed as weak relative to DNA evidence, but also relevant to the Bayesian models based on the subject's own estimates of the probability of error. So shoeprint evidence is weak in ways that DNA evidence is not weak, and shoeprint evidence is perceived as weak in ways that are not reflected in the juror's own estimates of the probability of various relevant errors. So what's going on here? I think what might be going on here is something that's similar to Susan Hack's notion of warrant, right? There's something about DNA, maybe to give a lot of weight to DNA evidence, people not only need to think to any forensic evidence, they not only need to think the probability of error is low, but they need to think it has a certain characteristic of quality, a warrant, which DNA has and shoeprint evidence somehow does not have. And thus, people are good Bayesians with DNA evidence. They're very poor Bayesians, or their judgments are incoherent on shoe evidence. I think that's the only way we can explain it. Regardless of whether you think that the Bayesian model is an adequate normative model of the way people should make judgments, I think the comparison of human judgments to the model tells us something interesting about how they think about evidence, and what makes them think evidence is strong or weak. So that's that. Do I have a couple more minutes? Do I have time for like one more? So where are we gone with this? This is interesting. What I think is problematic about this study is that it involves written summaries of evidence, and my thinking is that jurors might be able to understand evidence better if they hear actual testimony. So we've been trying to do studies with actual testimony. One of the people who, this is Jeff Morrison, who's an expert on voice comparison analysis and who's been a big advocate of the use of likelihood ratios to characterize forensic evidence. Written a lot about that, and he told me repeatedly that he thought, maybe people misunderstood likelihood ratios in jury studies, but if he could explain likelihood ratios to them, they would understand it. Well, it happened that Dr. Morrison was passing through Irvine on his way from Australia to somewhere else and asked to stay at my house, and I told him that he certainly could if he would allow me to depose him. And so I had him basically give expert testimony on likelihood ratios and to create stimulus materials for a jury study. So it was a crime occurred. We set it up so that the prior probability, the strength of the other evidence was either strong or weak. It was a voice comparison case. We then presented the forensic evidence in 3 ways. Either they got a written summary, or they saw a videotape of Morrison testifying, or they got an audio tape of Morrison testifying. He explained the likelihood ratios extensively, and the likelihood ratios were either high or low, 3,000 or 30. And so the goal is to see with this expert explanation, do people become more sensitive to likelihood ratios, to the variation in the strength of the evidence? And the answer is sort of. So what we're seeing here is results for the lighter bars audio, the medium bars video, the dark bars written, for high and low prior probability. They're very sensitive to prior probability, so the strength of the non-forensic evidence they're sensitive to, which is good. As far as the forensic evidence, it's either a likelihood ratio of 30 or 3,000. 3,000, they're a little bit higher, not as much as Bayesian norms would want them to be, but they are at least, unlike what Martiri showed in her study, they are somewhat responsive to likelihood ratio variation, which is probably good. The unexpected finding that I can't explain is that the greatest weight is given to the evidence when they hear just an audio tape as opposed to the videotape, right? So it's actually seeing Dr. Morrison's face and seeing him talking somehow reduces the credibility of his testimony in ways that for reasons that we don't quite understand yet. So that's what we've done so far. I'm looking into now other ways to try to reduce fallacious reasoning, and we've been making some progress using graphics like cartoons to illustrate the prosecutor's fallacy and things like that. That may work. We're doing other kinds of forensic evidence and trying to introduce lawyers' arguments in more realistic testimony, looking at comparing it to traditional characterizations. And so this is the course of the research, and I'm not able to give you any firm conclusion to the question I posed of which presentation method is best, but I hope at least this has exposed you to some of the thinking about how you might evaluate that question and what relevant data might look like. So I'll stop there.
Thank you, Bill. Your commentator will be Paul Brest, as you already yourself announced, and you already gave a very nice personal introduction to Paul Brest. I'll add some further information about Paul. We are very honored to have him here. He is an emeritus professor of law here at the Stanford Law School. He has been the former dean. He's an expert in constitutional law. He has co-authored a book on problem solving and decision making, and still is giving courses on that, which I think are very helpful for the law students here. But I think already for maybe a decade or longer, you are also strongly working now with the Hewlett Foundation, also as a director, and that's his philanthropic side. So when Marcello and I were finally looking for a room for this event, because we were a little late with that, we now think. There were not so many places left anymore. And we ended up in the Paul Brest Hall. We had to balance, let's say, the slight embarrassment to have Paul Brest speaking in the Paul Brest Hall, but, well, okay. I hope that you will not mind that we have so nicely Paul Brest here. Paul.
It's not so much the embarrassment as was captured by the comment of somebody who I saw when I first arrived. He said, "Are you still alive?" And that's really the thing. I check my pulse every time I walk past here. I have to say that in the same way that Bill's expert probably felt sorry that he had accepted the invitation to come to Bill's house and then become the subject of this experiment, I invited Bart to talk to my class, and then Bart turned around and said, would I be willing to be a commentator? This is actually, it's not my area, and all I'm going to do is make a few comments just to get things going. I mean, first of all, we are just very bad Bayesians, right? I mean, you studied, I expect, with Amos Tversky. He was at least in the psych department when you were here, and Amos and Danny Kahneman have spent much of their careers showing we are not very good at dealing with probability. I've just been reading a new book by Gerd Gigerenzer, who he and Amos Tversky have been at odds for a long time. But Gigerenzer believes that you can actually develop useful heuristics for dealing with probability, whereas I think Kahneman and Tversky basically think that that's kind of hard to do. I mean, the prosecutor's fallacy, which I didn't realize until I read Bill's paper, that he had invented the term. You know, why should we be surprised if people fall prey to the prosecutor's fallacy when you can find in statistics books people who are doing null hypothesis statistics testing confusing the probability of the data given the hypothesis and the probability of the hypothesis given the data. I mean, people who do this for a living screw up. So why shouldn't us ordinary people on jurors? So, I mean, I guess the most intriguing, to me the most intriguing general problem is the difference between the DNA and the shoeprint evidence. But I actually think it may be the key to understanding the broader problems. When somebody presents DNA, and this is very nicely described in the paper, Bill went over it rather quickly here. When somebody describes DNA evidence, unless you're one of the forensic experts in this room, you kind of have a notion of white-coated scientists doing something totally mysterious, but almost totally certain, right? I mean, and it's seeing the TV shows about DNA evidence. It's, you know, the Innocence Project where people are exculpated. You just treat this as it's real. Well, if somebody presents shoeprint evidence, you say, expert, I can figure that out myself. I can look at a shoeprint, a footprint, and, you know, that has to be really inaccurate also. I mean, how many different shoes are there after all that one can look? So I think that we tend to think that we are experts, and that the mock jurors tend to think they're experts looking at the shoeprint evidence. And that leads me to think that there's a prior to the Bayesian prior you're discussing, and I think you get at this, which is, you know, how credible is the evidence? It's a mixture. I guess maybe I'm conflating two things. How credible do you think the expert is? You know, the DNA expert is a real expert. The shoeprint expert, you know, maybe the guy who runs the shoe repair shop down the street. So there's kind of a prior discounting of that. And then, you know, as you said, kind of the weight of the evidence. So if you imagine that a juror comes into this with a strong prior that the DNA evidence and the expert presenting it, you know, really got it right, and the shoeprint evidence is weak to begin with, and any old person can do that, then it's less surprising, maybe, that you see some of these variations, because in effect, if the prior is really strong, these variations look like noise compared to a strong prior. At least that's a hypothesis which I would throw out, and I turn it back to you and then to the participants in this symposium.
Bill, do you want to respond?
I agree completely. Yes, I do think that DNA comes to court with tremendous credibility. Right? It's gotten good press. We've all heard about people being convicted and exonerated based on DNA evidence, and it's kind of mysterious. But it has a high degree of credibility. And I agree. Shoeprint evidence seems more problematic. I mean, I think the interesting part about the research is that shoeprint evidence is problematic in ways that are not captured by probability or by statistical estimates of the likelihood, the participants' own estimates of the likelihood of error. So participants' own estimates of the probability of a coincidental match or a lab error or of a frame-up with shoeprint evidence. those suggest that it's weaker, they perceive it as weaker than DNA evidence, but in terms of how they respond to the evidence when they get it, they treat it as weaker still than their own estimates of probability. And I think that what that tells us is that people don't, well, we knew people don't reason in a Bayesian way. I think this tells us some interesting things about the way in which people are non-Bayesian, and that there's something about the characteristics or quality of the evidence, or maybe their expectations about its value, that affects them in ways that can't be captured by the relevant statistics.
Question, Bill. I may have misunderstood something, because it's very difficult to catch numbers on the fly. As you know, numbers are confusing. But on your slides, when you were graciously giving your study subjects credit for getting things more or less right, as best as I could recall, the difference between weak evidence and strong evidence was several orders of magnitude, 3 or 5, I forget how many. And in the charts, at best, we're seeing a trend in the right direction. If the vertical scale was, well, it was log, and you were seeing a difference, maybe acknowledging 1 order of magnitude out of the 4 or 5 that were there to acknowledge. And so I think you were really too kind to these people, and they're not here and we are, so I think you should have been harsher on them and clearer for us.
Well,
if I understood.
No, I think it's a good point. This is a good thing to clarify. Now, if it were the case that our participants thought that the probability of lab error was 0 and the probability of a frame-up was 0, and they accepted what the expert had told them about the random match probability or the likelihood ratio based on coincidence, then what you're saying would be exactly right. That they would not be differentiating between the weak and strong evidence as much as they should differentiate. But when you take into account not just their feelings about the probability of a coincidental match, but combine that with their estimates of the probability of a lab error or a frame-up and so on, and combine those all in the way I said, the difference between strong and weak conditions was about what was shown in the chart by the striped bars, and their reactions to the evidence were commensurate with that, right? So the answer is that you would be right if you assume that what the expert said, if you assume that what the expert said was correct, but our participants didn't. I mean, they had their own views about the probability of a coincidence and an error and so on that they told us about, and their reactions to the evidence in terms of how they shifted after getting the evidence in their estimates of probability of guilt were more or less commensurate with that, at least for DNA.
Please convey my apologies.
I think Professor Brest's comment about, people thinking that they're shoe experts seems quite cogent there. Was there a reason that you did shoes versus DNA versus, say, I don't know, an obscure metallurgical test or something that would be sort of more like something where people wouldn't be inclined to think that they were experts?
It was mostly just based on pre-existing literature. There had been previous studies that show that people do seem to be sensitive to the strength of DNA evidence when it's presented with random match probabilities and other match probability statistics, whereas this study by Materi and her colleagues that showed that people were not sensitive to likelihood ratios when dealing with shoe evidence. So what I wanted to do was, in order to determine whether the difference was about DNA versus shoes versus likelihood ratios or random match probabilities, I wanted to put this all into the context of the same study so that I could disentangle the various strands and find out what was really going on.
Gotcha.
And
yeah.
Turns out it was a more complicated story than I expected, but that's why we did it that way. But I think that we need to look at a much broader range of evidence.
So I wanted to go back to Susan's talk, if I could, because there's some concepts that here, in terms of measuring things. To Susan, the question is largely, we talked about it at lunch, the difference between separability and distinguishability, and if you can talk to that.
Oh, goodness. Okay, I think the first thing I want to say, I'm going to say to both of you jointly, I was very struck when you talked about what these mock jurors were throwing in besides the strength of the DNA evidence was assumptions about frame-ups, lab error, etc. That is exactly and precisely what I mean by independent security. They were considering the independent security of this testimony, as well as how strong it would be if it were perfectly secure. Yes, so certainly we can use that aspect of what I was doing here. I'm not, okay, I shall say to, I can't look at you properly ever myself. I'm answering the question as put. I'm sure there's a distinction between concepts being distinguishable and there being separable. Sometimes you can distinguish the concepts, but the things always go together. Right? Sometimes you can distinguish the concepts and the things can occur separately. For example, the concept of what's legal is, in my opinion, a quite different concept from the concept of what's moral. That's distinguishability. And moreover, the two may come apart in practice. That's severability or separability, because there have been morally abhorrent laws. And in my opinion, they really were laws, even though they were morally abhorrent. Okay. And I suspect that this kind of distinction of conceptual distinctness versus separability might be important in what you're doing, but I'm in no position at this moment to say, here is where I would apply it. I can't do that. It would take a lot more thought than I've had time to put into it. So I'm sorry if I'm disappointing you, but I think it would be, I'd be taking a flyer and it's not worth it. I do have a question though. Did you ever look at jurors with different levels of education, for example, or more or less scientific background, or these are just jurors, generic?
Yes, I mean, we do that. We have them state their level of education. We ask them questions about how confident they are about dealing with science and numbers and so on. For most of the studies I've done a number of these jury simulation studies. For most of the studies I've done, it doesn't make it doesn't make a whole lot of difference. But there is one exception. Was a study about people drawing inference from the absence of evidence. When does the absence of evidence constitute evidence of absence, right? And so it's kind of a negative inference. And for that we found, people with college educations did fairly well. People without college educations tended to give no weight to the absence of evidence as evidence for the contrary hypothesis. Yeah, no, whether it's something that we teach them in college or whether people who are smart enough to go to college naturally get that, I don't know. But that's one area where there seems to be an educational level difference.
There is some time, so I can also ask a question if nobody wants to ask a question.
So first of all, thank you for your interesting talk. I was wondering whether we can suspect that we have more confidence in a technique of getting evidence, the newer the technique is. For example, shoeprints were used in Sherlock Holmes books, so it's very old. Fingerprints are something between shoeprints and DNA. So the newer the technique, the more the confidence of the jury in the technique. Maybe that you could also invent a fake technique to verify whether the confidence is even higher than that for a DNA technique, as far as you propose it as the very brand new technique in the legal field. I don't know how you could name it, for example, something like a nano-neural technique, brand new.
Nuclear proton activation analysis or something. No, it's very possibly true. I mean, there's been some research on psychology that looks at things like how much weight people give to psychological testimony, and if you include the word neuro in it, like neuropsychology, adding neuro like gives a big boost to credibility, right? Because it has something to do with the brain. Yeah, I mean, I think more broadly, it's made me realize I think we need to think about this, and that evidence can have levels of credibility that vary based. This is what this is what I think is really kind of striking, and I'm having difficulty with it. The credibility of the evidence can vary based upon factors that don't have to do with the probability that it's wrong, or at least with any model I can invent of the probability that it's wrong, right? So it's not just the probability that we could get a false result, because we estimate that. Beyond the probability of a false result, there's something about it that maybe makes it seem reasonable to convict based on one sort of evidence versus another, just based upon our perception of how strong it is, or how good it is, or whether that kind of conclusion is warranted or not, for reasons that have to do with something other than our estimate of the probability of error.
This is fascinating. The last few questions and answers, fascinating, and it's in that vein. I just want to maybe ask a similar question in a slightly different way, and that's this notion of measuring degree of warrant. If it's not, probability theory, and let me ask it this way, and I'd like your answer, Bill, and Susan's. Because the problem, as I was listening to Susan's presentation, the question in my mind was, is the degree of warrant between the evidence and the conclusion an empirical question? And given your paper, let me ask it this way. From your study, if we do a study like yours, do we determine just that jurors find DNA evidence more credible than shoeprint evidence? Or do we find that the degree of warrant in DNA evidence is higher than the degree of warrant in shoeprint evidence? I mean, whether the evidence really is more warranting in the DNA case.
Yeah, well, I think you're drawing a distinction that's really important. In a sense, as a psychologist, I'm dealing with the easier issue. I'm looking at people's perception of the credibility or the perceived warrant of the evidence, whereas Susan's dealing with the harder epistemological question of as a normative matter, what deserves more credibility. So I think those are separate questions, and what will be interesting as we explore this is to see ways in which the perceived warrant of the evidence might diverge from some epistemological theory of warrant, which would lead us to believe that people might be giving more weight or less weight than they should to the evidence. So I think this is an area where I think we have to look at we have to simultaneously think about how people are responding to the evidence and how they should respond to the evidence in order to say anything sensible.
So. Okay, who was it? Where are you? Oh, Vern. Okay. Is it an empirical question? I would say it's at least partly an empirical question, because if I'm right, relevance is a material concept. It's not purely formal. Right? So it's got something to do with how the world is. Right? And since some of the dimensions of quality of evidence call on the concept of relevance, then quality of evidence is going to be at least partly empirical, would be my answer to that part of the question. Sorry, I'm twisting and turning here, but what I wanted to say to what you just said, well, I find it fascinating what you can find out about how people perceive the quality of evidence. But of course, there's more than one way in which you might use what you find out. One way is, how can we get this evidence presented so that they do the best that they're capable of, the jurors, I mean, right? Right, that's the way you're looking at it. But if you were a working attorney, you might look at it at, how can I best present the evidence so that they go my way? That's right. So we definitely need both your thoughts about how it's perceived, right, and some idea of what we're trying to do with that, right? I want to do with it what you want to do with it, but I can well imagine someone legitimately wanting to do something else with it. Okay?
Right, and that's why I think it's really important to think about, you know, what are we really trying to accomplish when we're regulating the way experts present their evidence, right? I mean, it's not just helping one side or the other. It's not just helping one side or the other win. There has to be some sort of framework or criterion for a desirable response, you know, and you know, my thinking as well, we want them to be sensitive to the evidence, we want to avoid obvious fallacious conclusions, and we want their various judgments about the evidence to sort of cohere or hang together well. You know, and you're in agreement on those? Okay. So if you agree with me on that, that gives me great confidence to go forward. Okay, go ahead.
There was a Florida case, Ramirez. It's now notorious, right? It's been going on for 20 years. In the last stage, the fourth trial of this guy, their knife mark identification evidence was ruled inadmissible. They're using shoeprint evidence. And this is what I'm told about how they presented it, how the prosecution presented it. Photograph of a square of grey carpet, strong light shone on it. If you look at this under this light, some of you will be able to see that there's a shoeprint there. And as soon as one juror said, yeah, I can see it, guess what? The others began to think that they could see it too. So that there are ways of presenting that you haven't even thought about that can have a considerable effect on the perception, almost literally in this case.
Yeah.
A final question by Margaret Hagan.
Yes. Hi. I was intrigued by the point on your last slide that graphics can have real power in this discussion too. I've been studying a lot about communication design, information design, how we can get people in other contexts to engage with legalese and fine print. And I was wondering if you could tell what kind of graphics capture the attention, where that resonance can be found. You mentioned cartoons and comics. I was wondering if you see some points.
Yeah, narrative graphics. It has to tell a story. I mean, I'm convinced. I'm excited about this. What happened is I attended a conference at Irvine on scientific communication, and there it was also being attended by a graphic artist who was interested in doing graphics for science. And I got talking with this guy, and we now have this collaboration going. We're creating a series of what I might call scientific evidence comic books, where trying to explain various aspects of things like the prosecutor's fallacy and the defense attorney's fallacy, and we're trying to. We have one on the the British R versus T case. The creation of likelihood ratios from shoeprint data and so on. You were just starting to test them out with people to see how they respond. But I'm already very confident that it's going to be enormously helpful just because they're so engaging. When you get swept up in the story, where the arguments are made real by saying, imagine, Well, I can, if you're interested, I have a few with me. I can show you some of my comics later. But I'm convinced this, I'm convinced that this is one helpful way to get lay people to think about this more rigorously and analytically.